God exists, then it means that somebody should have seen him. Now, philosophers have grappled with this because the opposite side always argues, that is called Purva Paksha in the philosophical discussions. So Purva Paksha says God doesn't exist because you can't see God, where nobody has ever seen God. Now we are in the same situation so far as electricity is concerned. Nobody has seen electricity, so it doesn't exist. So the answer to that is no, there are two ways in which you can make sure that it exists. One is Pratyaksha Pramana, the other one is Anumana Pramana. Now, Pratyaksha Pramana is actually seeing it with your eyes and perceiving it with your senses. Prati Aksha is right in front of your eyes. That's what it literally means, but it also includes experiencing it. So, Pratyaksha Pramana, you can't do it. The next one is Anumana Pramana. Anumana Pramana is inference. So, if there is smoke, there should be fire. On top of a hill, you see smoke, but there is no, you don't see any fire. So what does any rational person conclude? Is that, well, if there is smoke, there had to be fire. So there is fire there. But have you seen fire? No, you have not seen it. Now, electricity is the same thing. We all know electricity exists. Pratyaksha we don't see. Anumana is if you put your finger into a socket, you're going to get a shock there. You switch on the light and you have electricity flowing into your current. So it exists. Okay, how does it exist? That's another issue. Now, it exists in a form in which it can be seen, enjoyed, but not perceived. So how exactly do you then come to grips with it? Because this issue has come up. 1 minute, I think some of my colleagues are telling me that the link sent is invalid. So some of your technical guys can, please sort that out. Sumana told me, Nagesh also told me same thing. So 2-3 of them have not been able to log in, they say, but I see that others are logged in. Okay, anyway, we'll continue. So what was I saying was that in Anumana Pramana, you're able to establish it. Why I am giving you this background is that it has often come up before courts as to what is electricity. And courts have had to grapple with trying to define what electricity is for the purpose of various legislations. And one of the earliest decisions of the Supreme Court, the question arose whether the sale of electricity by a utility to a consumer, does it partake the character of sale of goods? Because the argument was there are no goods. Where are the goods? You don't see it, you don't feel it, and then it doesn't exist. So it cannot be. What are goods? A lot of elaborate discussion went on. And finally, the Supreme Court concluded that electricity is goods. So in other words, electricity is regarded as goods, though you actually don't see it. Now, this similar issue arose many years later, insofar as the bandwidth sale is concerned. See, one argument was that when electronic pulses are generated, does that give rise to a delivery of service or is it a delivery of goods? So I'm saying that the new inventions that came about in various fields have given rise to a number of issues like this, which we are all trying to grapple with, not only in the field of electricity, but in electronics, in data processing, the location of where the data is. All these are issues which have come up because of technological changes that have come about in our lives because of new inventions. So it is in this background that if you look at the Indian Electricity Act of 1910, and I must tell you with some pride that Karnataka, or the old state of Mysore, was the first state in the whole country which came up with a hydroelectric power generation station even before the Electricity Act of 1910. So you can see how progressive our rulers were, and how exactly they were functioning, and how they foresaw the changes. That first electric power station was in a place called Shimsha or Shivasamudram, where for the first time hydroelectric power generation was set up. Now, what is it that the Indian Electricity Act attempted to do? The preamble to the Act simply says, this is a law, an act to amend the law relating to supply and use of electrical energy. So that means there were different legislations which were not in the form of enactment, but in different forms. And that is what the central government tried to do with the Indian Electricity Act. Now, those of us who are familiar with this field of electricity, you will realize that most of the power generation was in the state sector. The state used to generate the power, and all generating stations were set up by the state in the infrastructure sector. There was hardly any private sector player in it. Of course, the model that India adopted after independence was somewhat different. But even before independence, there were no big players who wanted, because the sector itself was new, technology was not so easily available, but an infrastructure cost was somewhat phenomenal. Therefore, what happened was that they depended on the state. So when the state started organized way of supplying electrical energy, because the state then realized that for progress, energy and lighting and power, motive power for industry is something very, very essential. So it tried in this enactment to sort of grapple with number of issues that arose. First issue was, they call it electricity or electrical energy. Now, what is energy? The Act defines energy as electrical energy generated, transmitted, or supplied for any purpose. And it also said, or used for any purpose except the transmission of a message. So they were grappling now with the Telegraph Act, which was about 15, 18 years prior to this enactment. So telegraph was also transmitting messages by means of the Morse code and other things. So they wanted to make it clear. So this was how it started off. And the object of this enactment of the 2010 Act was mainly to ensure that it is possible for electrical energy to be disseminated and to be widely available over to all the population in the entire country. Now, if this has to happen, what was the regulatory framework that they thought of? How should they facilitate this? First thing they said, license Raj means if you want to have breakfast, you take permission from some deputy commissioner. If you want to have lunch, you take permission from the deputy chief minister. If you want to have dinner, you take permission from the home minister. This is the methodology of regulation that India has seen now. So first and foremost, what they did in this act was they provided that you must take a license. And who can give the license? The power was given to the state government. Now, the provisions of the Indian Electricity Act, which I'm going to take you through, I won't be reading sections and things like that, but broadly giving you an idea of what it includes. You will be hearing references to many terms and developments. The Indian Electricity Act of 1910 was amended several times. It went through a large-scale amendment after the Electric Supply Act of 1948 was enacted. Because you will find references in the 1910 Act to the 1948 Act. So you may be wondering how this is possible. The possibility is because of the large-scale amendments that are incorporated into the Indian Electricity Act of 1910 post the Electricity Supply Act of 1948. So wherever you hear these 48 sections, so you don't need to be sort of alarmed. So the first thing they said was, take a license. And they said, who can give the license? They said, it's the state government that can give the license. And for what the state government has to give the license? It is to supply energy in any specified area. So in other words, if energy was available and energy had to be supplied to, let us say, Bangalore city, then a company here could apply to the government and say, sir, I want to supply energy in Bangalore city. Please give me a license. So once that license is given, then that licensee could then start supplying energy. And there are a number of provisions relating to how this license should be granted, the usual rigmarole about enforcing it, cancelling it, etc., etc. It also provided that the licensing, once a person has given a license, then the licensing authority, there was a state electricity board that was constituted. In Karnataka, it was called the Karnataka Electricity Board. Now, this electricity board was constituted under the Supply Act of 1948, because till the Supply Act came, the concept of a separate board being there was not there. If you might recall, even for example, the Hindustan Aeronautics Limited, which is now known as HAL Limited, it was a division of the Defense Ministry. It was an activity of the Defense Ministry itself. It was just a factory established and working under the aegis of the Defense Ministry for aircraft and other businesses. As the corporatization process started, the Hindustan Aeronautics Limited was incorporated as a company. And this division was transferred to the Hindustan Aeronautics Limited, which got continued in that capacity. So what I'm saying is that there was no entity. It was then directly an activity of the government itself, and it was a part and parcel of the actual functioning of the government itself. Now, just like any other regulatory framework is there, the Indian Electricity Act also said that if there is a person who obtains a license for distribution of electricity, that person cannot indulge himself in selling fish and eggs. In other words, the licensee cannot do anything other than actual distribution of license of energy, and nothing else can be done by this entity. And of course, without taking a permission from the state government. Now, it's easy to just provide. I mean, just put yourself back 100 years ago. We're talking about at that time. Okay, there were no electric lines laid down. There were no transmission lines that were there from generating point. There were no generation points. And the idea was to give power to everybody. So a large number of new establishments and installations were required for this purpose. Therefore, the Indian Electricity Act contained detailed provisions about how new works should be undertaken. And in that context, there is some overlap of streets, tramways, canal, waterway, and other things, because the street lighting and other things came much, much later. Then this also introduced a problem. You see, on the streets, anybody could be walking. And if you suddenly draw an electric line there, what is the right of this licensee to draw the electric line? In fact, we are grappling with this situation even currently under the new legislation, with a PIL being defended by my chambers. The main problem in that is the electricity companies place their transformers on pavements, that is on footpaths. Some public spirited person filed a petition to say that these transmission systems which have been placed on the footpath are a great hazard for everybody's life, and therefore they should not be placed there. There's no law under which they can be placed there. Such a contention has been raised, and of course we were able to defend it and show to the court that there are laws which enable this to happen. Now, same thing, for the first time when law was being made, the Indian Electricity Act made detailed provisions. It said that the licensee can lay supply lines. He can use the existing underground sewers, pipes, or other systems that are available for public use. Then it also provided that gave them the right to break up any road, sewers, tunnels, go under somebody's property, because supposing your house is in the middle and the line has to cross from this side to the next side, there's no other way. They have to go below your earth only. So in a situation like that, is it possible? And you have to go above it also. Even today, if you go to the villages, you'll find there's a farmhouse, there's a neighboring farmhouse. Now, if the line has to go to the neighboring farmhouse, the line has to naturally be drawn through your farmhouse. There's no other way in which it can be done. So why I'm giving you these examples, these situation is, today we are in a different situation. You go back in time and then you'll realize all this was absolutely necessary to enable the building of an infrastructure that was needed for the modern electrical system that we have. Similarly, if there's a telegraph line or an electric supply line that is going somewhere there, if somebody has to do something with that, now supposing next to your house an electric line is raised, or there's a transformer established somewhere near to your compound, you can't go and do whatever you want with that. So if you want to do anything relating to that, you have to go to the licensee, and you have to seek permission from the licensee and see that safety is maintained, and such restrictions are wholesome in the object of ensuring the proper supply is taken. Now there are also problem. Now supposing in villages even today we see there's an electrical line running, there's a wedding in the family. Coolly they will just log on to the line that is there on top by a simple electrical wire, and they start using electricity. Free electricity supply is there because the line is energized and they can start using it. So for these also, right, in 1910 there were provisions which says that nobody can obstruct or utilize the lines of the licensee which is meant for transmission of energy, and he cannot meddle with any establishment of the licensee. Now, this is all the rights of the licensee. But what is the obligation of the licensee? The obligation is that within the area for which the licensee was given a right to supply, whenever anybody comes to them and asks for supply of electrical energy, he is bound to supply energy to that person. Even today, again after 100 years, we are still grappling with this situation where when I come to the current scenario, I will explain to you how the current regulatory mechanism is working, how much of effort had to be made to ensure that a person who needs electricity, who is willing to pay for it, they have not been able to give them electricity, and how exactly should that be achieved is something which has been subject matter of quite a bit of debate, and there are these provisions to that effect also in the Electricity Act of 1910. Now, when the licensee has been granted a license by the state government naturally retained for itself some powers, and it said that they could give some directions to these licensees, and the licensees will function in accordance with the policies that have been laid down by the government. You also have a number of provisions relating to how charge for the energy should be made. Merely because a license to supply was given, does it mean that the licensee could charge anything or not charge, or charge some exorbitant rates? So there are provisions for regulation of all of those things. Also, since this is a somewhat statutory in nature, since a licensee is granted by the government to run this system, supposing a person who consumes energy stops paying for it, doesn't pay for it, then where is the right to act against him? So for that, there were provisions which made that supply to a consumer can be disconnected in cases where there is a situation where the consumer does not pay any amount which is due to the licensee. This is so far as the last mile I'm talking about. Now you have to go back. When you go back, how does energy reach your house? The units of energy which I'm consuming in my house, they may be generated in Shivamogga, in the Sharavati power generating stations. They may be generated in the power stations that have been set up in Kaiga nuclear. It may be generated from a wind-based project set up in Chitradurga, or it may be a diesel generating plant which is set up in near Yelahanka or near Raichur. Now, these are generation points, and from there for the energy to reach the consumption point, a transmission system has to be provided. What is this transmission system that we are talking about? The transmission system is that as all of you know, I started my talk by referring to electricity as goods. Now, if you go to a shop and you buy 5 kgs of rice, you'll carry it in your bag, bring it home, keep it safely, and use a quarter kg every day till you finish the 5 kgs. When it comes to 4.5 kgs reorder level, your wife will tell you, please go and get more rice because we need from tomorrow, day after tomorrow, we'll need rice. So in other words, the goods generally that we talk about are capable of being stored. You can see it, you can perceive it, you can keep it, you can store it and use when you want. Now in electrical energy, that is the main problem. That there is no way in which you can actually store electricity and utilize it elsewhere at a different point of time. There are new developments relating to solar and the electric generation cars. I'll come to that a little later about technological changes that have been made. But I am talking again going back to 100 years ago. It was the lawmakers were conscious that there is no way in which you can actually store energy and use it at a different point of time. So in other words, it is an instantaneous process of generation of power, transmission of power, and consumption of power. These things have to take place in real time simultaneously. A unit of energy generated in Shivasamudram has to come to a point where it is consumed, because if you see, most of these generation points are not in the middle of the consumption points. For example, I think Bangalore city and its urban environment, they consume something like about 35 or 40% of the energy that is generated in the whole state. Now, if that is so, this generation is not in Bangalore, it is somewhere else. So it has to be transmitted. So the law contemplated the setting up of a central transmission utility. Initially, it was the state. Then as the law developed, it became necessary to set up a national central transmission utility and a state transmission utility. Now, why the central and state is like this? Let us say the central government has set up number of power generation plants. NTPC is one such example. It's a wholly owned government company. It has number of thermal power generation plants. Similarly, National Hydroelectric Power Corporation has set up number of power generation companies in different parts of the country. These companies generate power. What should happen to that power? That power which is generated by NTPC near Hyderabad may have to be transferred to Gulbarga for use in Gulbarga city. It may have to be transported to further somewhere near Dharwad also, because the consumption point for it is not only in Hyderabad or not only in the state of Telangana now and earlier Andhra Pradesh. It extends to different areas because the central government has set up this purpose to enable the energy to be available for distribution and consumption. So how do you do that? Now, for that purpose, energy has to be moved, and for that there is a transmission that is needed. So the central transmission utility is something which ensures interstate movement and provision of infrastructure. Now, energy which is generated is transmitted at different voltage. See, a technical thing is, the higher the voltage at which you transfer power or transmit power, the lower is the transmission loss. You see, energy, when it is fed into a point, a line, an electrical line is drawn, let us say. Take a simple case, okay, you're living in a farmhouse. You got a main house and you got an outhouse, which is for some guests or your, helpers or servants or whatever it is. Now you energize the main house. Now you have to energize the outhouse. So what do? You draw a line and connect this outhouse to your main house. Then the energy which is being used in the main house, the minute you plug it in, there is a plug system which is a little more sophisticated in terms of generation transmission utilities. There's a transformer, step up and a step down transformer, and there are switch gear. When all that is utilized, the minute the electricity is generated in the generator, whether generator is the one which converts different forms of energy into electrical energy. And the principle is very simple. Basic physics, which we had studied in school, will show you that when you have two magnets and an electric current motion is made, then that generates energy. That energy is received through coils, and the coils will then allow that energy to get dissipated through an evacuation mechanism. Now, when you do that, the electricity which is generated then and there must immediately get transmitted. Because one other thing is, if energy is generated in a generator and there is no transmission of that energy, then what happens is that the system which is generating the energy is going to destroy itself. It is not possible for it to contain the energy. That is the reason why we have now various fail-safe mechanisms, which I will describe a little later when I come to the current scenario, where if evacuation is stopped for some reason, then automatically the generator shuts down. Now, if this happens in the case of a thermal generator, then it's a big major headache, because the rotor which is rotating inside the generator, it has to rotate at a certain speed. If it suddenly stops rotating, it will then solidify and the whole generator will get completely seized. This used to happen in the old generation cars, which we had seen. So why I'm telling you this background is that the importance of the transmission mechanism was very, very high. Therefore, for interstate transmission of power, they had the central utility. And for intrastate, now, for example, in the illustration I gave you, there is a generating power station in Yelahanka. It's a thermal generating station based on coal. Power has to be brought from Yelahanka to Bangalore city. There's a transmission line that is needed. This transmission line belongs to the state, which is inside the state. Therefore, the transmission utility of the state will look after that. Now, these transmission utilities, do they also have to take license or are they free for all? So the law provided, no, transmission utilities have also got to take a license from the state government if they're state transmission utilities. And if they're central transmission utilities, they have to get it from the central transmission utility. Now, I won't go into the nitty-gritty. The 1910 Act also provided very progressively thinking. Now, if supposing, let's say, there's a big industrial township, for example, an NMDC, National Mineral Development Corporation in Donimalai. It's a big industrial township. I think there are some 20,000-30,000 people living in the township and they're working there. Now, in a case like that, if that company wants to set up an electrical generating plant itself to supply power to its own consumers, they could be the factory, they could be the offices, they could be the private consumers who are residents of that area, and maybe a few outsiders also. Say some shopkeepers are there, they are not employees, some small businesses are there, some utilities are there. All of these people need energy. So if they're going to supply to all of them, do they also need to take all these licenses? The Act contained a provision which said that it is not necessary to take all those permissions. And these permissions, when it's done on a captive basis, permission is not needed and they can work on their own. Now, electricity is hazardous. It is capable of causing life and death. It is capable of causing damage, fire, etc. Accidents do happen. Unfortunately, due to contact with electrical energy, people can lose their lives, they can lose their limbs, etc. So the Act also contained number of provisions relating to the powers of these licensees and the powers of the state government. There was the Office of the Chief Electrical Inspector, which was set up under the Act at the state government level. So the state governments used to appoint the Chief Electrical Inspector who was working under it to ensure that licensees and other people who are participating in this electricity sector, they all function as per technical standards, as per safety measures, and all installations are properly kept and maintained. So for this purpose, the Act also contained detailed provisions relating to appointment of electrical inspectors, their powers, and the Act usually contains the normal provisions of rule-making power and on various subjects, because to give effect to the Act, rules have to be made. The last portion in the Act contains criminal liabilities. Now, in the example I was giving, you're having a function, you just hang on to the line and use power illegally. That is termed as theft of energy. So if somebody uses it like that, then that is an offense which is punishable under the Act. Same thing, if somebody causes some wrongful injury to some electrical works that have been established and uses or allows a non-licensee to meddle with all these things, these are also offenses. Like this, there are a number of offenses. But the main offense and the main problem which has arisen, which we have noticed, is collection of back billing charges. Now, supposing these consumers are very, very intelligent people. You are in steel industry, you are consuming large volume of energy every day. The energy has to be metered, and all of us know that there is what they call as a trivector meter that is installed for high tension power. So when you are drawing that meter, every unit that you draw, and there is what is called as a demand. A demand is the maximum power capacity that you are utilizing at any point of time. See, when you apply for power, You will have to give them what is your load, that is called the power requirement, and what is your energy consumption that is required. Based on this, the licensee will make arrangements for supply of installation for you. You must have a proper transmission system. You must have a proper transformer. You must have proper switch gear. All of that established inside your premises. Now, in addition to all this, how do you measure electricity? We are all familiar in our houses. There's a small electrical meter. If you just go and observe the electrical meter, you will find a small rotor inside. Whenever any energy is being used, that rotor is moving slightly, in a very small way, the rotor is rotating. You just come inside a house and switch on 4 air conditioners and 3 fans and go outside and observe that rotor. That rotor is running at 4 times the speed it was normally running when the air conditioners were not on. What does that mean? It means that the meter is recording the flow of energy from the grid into your house. Now, most of these power manipulations and theft cases arises because of companies which consume huge volume of power. One example I gave you was the steel re-rolling industry, steel manufacturing industry, the hot iron furnaces that they have. They consume enormous amounts of energy. Now, just imagine if they tamper with the electrical meter that is there and make sure that instead of running in normal speed recording, it records at say 50% of the speed. So they are consuming 10 units, it will record only 5 units by slowing down its speed. This goes on for some time. Suddenly the electricity company realizes so much load is going from this particular feeder, but the recorded units are much less. What is happening to the difference? Energy cannot vanish into thin air. It has to go somewhere, and the only place it can go is into the coffers of a consumer, or what they call as technical loss. This technical loss means, see, energy when it is fed into the grid meaning that the transmission system, the step up and step down transformers, the switch gear, and then these huge pylons which you have seen, which carry energy at 11,000 kV, kilovolts. That's energy transmission level at which it is high tension power is transmitted. How is it transmitted? There's electrical line. The line is different metals are used. It's used to be copper earlier. Now it is slowly changed over to aluminum and various other modes. There are also some hybrid technologies that have been used now. So what is it that this line does? It receives. It is like a pipe. If you want water to flow, you first lay the pipe. You want to water your garden, you take a pipe, you connect the pipe into the tap, and you're ready. When you're ready to water, you turn the tap on, energy flows, the water flows into the pipe, and you get it at the end of the pipe and you use it for watering. It's the same thing so far as energy is concerned, but the only thing is you cannot see the energy, but the electrical energy that is generated is fed into this transmission line. So the minute it reaches the transmission line receives that energy. Now energy is getting into the line. Now there is a law of physics says that there is some resistance. Now simply if you just see, if you pour a small drop of water on top of let us say a glass plate that you're holding, you will immediately notice that some droplets come straight down, some droplets will stick onto that glass plate, and if the sun is very high, in a few minutes time, that droplet which did not fall down dries up and it evaporates. So in other words, the quantum of water which you gave on the top and the quantum of water that you got at the bottom is not the same. It is influenced by several factors. One factor is the resistance that is there. Two is the heat and the radiation which leads to evaporation of water. In a similar fashion, when energy is generated and energized into a line, there is no evaporation in the case of energy due to atmospheric condition. But the extent of resistance of this transmission line varies slightly with the atmospheric temperatures. So there's a slight variation, but it's not proportionate like water, as I was explaining. So this energy which is fed in at point A and which is evacuated at point B, let us say the distance is 5 kilometers. Now the energy which you energize at point A is not, supposing 10 units you energize here. At the end of point B, which is at the end of say 10 kilometers, you will not get 10 units. You will probably get something less. How much less is something which is technically possible to estimate. It depends on number of times the energy is stepped up and stepped down. Because as I said, long distance high tension transmission is at 11,000 kilovolts. Whereas what you and me, we consume inside our house is 220 to 240 volts. So kilovolt is a 1000 volts. So 11 kV means 11,000 volts is stepped down for our use to 220 volts. Because if your power into your house is instead of 220, it goes to 400, you will have a lot of fireworks inside, and many of your electrical appliances may break down, subject of course to safety mechanisms that you might have introduced, like what is called as an MCB circuit board it is. And this circuit board will ensure that excess flow of energy will immediately de-energize the system. Why I am giving you all this is that this interference with the measurement of the power consumed, and as a result of tampering that is done at the meter level, is a major problem. Now, this major problem is sought to be resolved even in the 1910 Act by providing severe penalty for such, and also it also contained many provisions saying that if you extinguish a public lamp, that is also wrong, or if you negligently waste energy, that is also an offense. Like this, number of offenses are also noticed, and offenses of by companies are also made a provision for, as a result of which the officials, the directors of the company are also made answerable. Another provision which now is of currency is arbitration. Now there is a provision for appointment of arbitral tribunal if there are any disputes which have to be resolved, and that is in regard to state government, state electricity board. Now I am referring to board because that was what was current from 1948 onwards. The situation is different now, which we will come to a little later. Now the Act also contains the usual rest of the provisions, but one interesting part of the Act is that there is a, why I said it's a statutory contract. What is the meaning of a statutory contract? Now, if A and B want to enter into a contract for supply of goods, let's say I want to buy rice, and I go to a rice trader and he says, I'll supply you rice, we enter into a contract. This is a contract personally between two entities, two companies. Now, supposing, let's say a government is dealing in the food grains. You have the, let's say National Fertilizer Corporation is there. They're dealing with fertilizers. So you want to buy fertilizer. You go and ask them, I want to buy so much tons of fertilizer. You enter into a commercial contract, you do it. This is a normal contract. But when the law provides that a contract can be entered into, a contract meaning a license is given in a particular case, and when the law says license can be given on fulfillment of certain conditions, but the fulfillment of that condition does not mean there's no other obligation. We are now laying down in the law itself as to what are those rights and obligations. So when the law provides what are the deemed incorporated provisions of any contract, though it is a contract, then when the law prescribes it, then it is called a statutory contract. All contracts, including licenses granted under the Act, are statutory contracts because the schedule to the Indian Electricity Act clearly and specifically lays down what are the terms and conditions for supply. Now this brings us to the end of the 1910 Act. Now half a century goes by, new things take place, and so then it became necessary to incorporate new legislative measures in the Electricity Supply Act of 1948. Now, if you see that act, it says it's an act to provide for the rationalization of the production and supply of electricity and generally to take measures conducive for electrical development. So in other words, after 50 years, it was felt that it is important for us to modernize the law, and it was soon after independence that this law was enacted. Now, what is it that it did? Brought about some changes. It brought into being because India is a federal structure. We have unitary and federal concepts both here. And as all of us know, the seventh schedule to the Constitution contains three lists: the state list, the union list. First is the union list, the second is the state list, and third is the concurrent list. Now, electricity is falling in the concurrent list. In other words, law can be made by the state legislatures. It can also be made by the central government or the union parliament. Now, the law on the point is quite clear. In the matter of laws falling under the concurrent list, if a state has made a law, that will prevail in that state. But if the center chooses to make a law, then the central law will prevail and override the state law, unless the central law carves out an exception and says that to this extent we are covering in our legislation, but the following things which are contained in the state legislation, they will continue to operate. That can be made a provision. So when I come to the 2003 Act, I will explain to you such a legislative mechanism has been used in section 185 of that Act. Now, this is one way of legislation. The other is, supposing there is a central legislation and the state legislation, they want to make some changes in the central legislation. Now, how do they do it? Article 254 of the Constitution provides that when the state legislation wants to make a provision which is covered by the central legislation, then such a legislation, if it is made with the approval of the president, then to that extent, the state legislation will prevail in that state. So in other words, Electricity Act of 2003 is there. If Karnataka government wants to now make a law with different slight differences, if it prepares a statute and obtains the assent of the president, then the legislature passes it. Thereafter, this amended provision will apply so far as the state is concerned. Now, this is a common example which we can look at. In the Civil Procedure Code, you have many state amendments. Most of the states have amended the provisions of the central legislation to suit their requirements. And to the extent of all these state amendments having been received the assent of the president, in that state, the CPC as amended in that state will apply. So that's a common legislative mechanism that is done. So when it comes to the Electricity Supply Act, this is also again, as I said, concurrent list. They first thought of setting up a central electricity authority. And the central, because now they're dealing with the whole country. See, 50 years have gone by. India has just got independence. And in this 50 years or 48 years or whatever period, lot of developments have taken place, technological developments have taken place. And the law has to now provide for these things. So what do they do is, they say, the only way in which we can actually go forward in energizing India and making it modern is that every state government must set up a state electricity board. Now, this electricity board is the one which will have the responsibility of generation, distribution, transmission, everything so far as power sector is concerned. And this will also facilitate, if in the example I was giving, supposing in the state of Himachal Pradesh, there is a huge surplus generation of hydroelectric power because of the mountainous terrain there. They generate more hydroelectric power than what they use in the state. So in a situation like that, what should they do with that energy? Let's say they want to sell it to the state of Delhi. They can have an agreement. So who should have that agreement? The State Electricity Board of Himachal Pradesh, along with the government of the Union Territory of Delhi, they can have an agreement. In terms of this agreement, the supply of energy can be talked about and all the rest of it can be done. Now also, each state has got different resources. Some have got more hydropower, some have got more capacity for wind energy. Now, that is, of course, all recent times. So, to ensure that there is an equitable distribution, the Supply Act also contemplated that for better utilization of natural resources of the country, states can enter into agreements with each other so far as the power transmission, etc., is concerned. Then there are the usual provisions relating to how this body is to be formed, etc., etc. Then this regime, which brought about in Section 18 of this Act, relating to the State Electricity Board and generating companies, held the field till 1998, and shortly thereafter, when the new electricity law of 2003 was formulated. Now, the law also in this section 18, it provides what are the duties, what are the powers, and what all this electricity board can do, and how it can borrow monies, it can have agreements with various parties, it can enter into arrangements with many people, it can ensure that all the works within its territory are properly kept and maintained, and they can also generate power and have a scheme for generation. So what is missing in the 1948 Act is what was not conceived then. They thought that the electricity is going to be 100% state-owned activity for all time to come. They never envisaged that private sector investment was possible so far as this is concerned. They never thought that even private companies or non-state bodies will be able to introduce and bring in capital so far as these companies are concerned in the power sector. That was not envisaged, which we'll come to a little later. I'll give you a little background of why that happened and how it happened. Then the Supply Act also contemplated for the first time that it is possible for one board to sell power to another board. In the example I was giving, Himachal Pradesh has got surplus power. It is not using it. Delhi needs power. It can agree to sell power to Delhi at a price at which they may both negotiate and decide. There is no third party agency that was involved. It is essentially a discussion between the buyer and the seller. And when the deal is struck, the matter ends and the supply can be made. This also provides for setting up of generating stations. Now, there are supposing I want to transmit power in a particular state. I go and apply for granting a license. They give me a license. Then I want to also start a generating station. I want to set up a thermal power generating plant. Even for that, a licensing provision was contemplated under this. Now, who should own these transmission lines? Because if you have a generation in one point, without an adequate transmission system, it is not possible to utilize the power generated. No? So this critical importance is the setting up of transmission lines and all the requisite paraphernalia that is needed to ensure that the power is transmitted from one place to the other. Now, for this purpose, again, a new concept which was unheard of at that time, which I will talk about later, is called open access. There are transmission lines which belong to the state. The state had put up at its cost. It is using it for generation and transmission of power from one point to the other point. After the transmission is over, what do? Supposing the capacity of the transmission line is, let us say, 10,000 megawatts, but they are only transmitting 8,000 megawatts. They can transmit 2,000 more megawatts, but power is not available. There's no one who wants. It is like, building a beautiful road from Bangalore to Chennai. And imagine a situation if there were only 100 cars in Bangalore, and this beautiful road you built, four-lane highway, you can reach Chennai from Bangalore in less than 3 hours, let us say. But number of cars in Bangalore are only 100. So what will happen? Obviously, that highway is underutilized. It is not being utilized. Only out of 100, 10 cars may go through. Remaining, the highway is just lying. Same thing with transmission. If you have built a transmission system, you must use it. So the law then did not contemplate. It only contemplated that the central commission which was established is going to look into these transmission lines how they are going to utilize the transmission lines, and what should be the terms and conditions on which this transmission lines can be actually utilized for towards better employment and better utilization of the assets. Then at what should happen to the person who wants to transmit power? There are some detailed provisions. I will deal with it when I come to the new 2003 Act. Now, the 1948 Act also contained number of other provisions which are not so relevant. So I'm not really going to trouble you with that, because we will understand and deal with the latest legislation which is now prevailing, which is the one which we need to understand properly. There are the usual provisions relating to how the board should be constituted, its accounts should be prepared, etc., etc. And some penalty provisions are also given, and general power to make regulations, etc., is also given. And there are some special exemptions and provisions so far as some of the taxing statutes are concerned. So this brings me to the end of the two. Am I audible?
Yes, sir. Thank you once more.
My screen is frozen, but I can hear you.
Yes, no, thank you very, very much for this amazing, erudite, and such a simple explanation of a complicated topic. I'm sure each of the listeners is greatly benefited. Thank you very much, sir.
Yeah. Now, there are some questions we can take so far as this is concerned on the historical perspective. I think I'm not connected.
You're connected, sir. Everybody can hear you. They're just,
okay.
I don't think there's any question that has been posed yet. But if I may ask, sir, historically, is there a jurisdiction that India looks up to in terms of regulatory expertise in the energy sector? Is there any particular comparative law body that is useful to be familiar with?
Yeah.
Or is there no such thing and it is sui generis in India?
No. Actually, I'm going to touch some of those aspects when it comes to the 2003 statute, because the reform process which was started in 1998, it started in 1998. The World Bank, you see, India was always short of energy. It was not in a position to utilize, its natural resources because of lack of energy. And also it was a human problem. So they tried every means by just asking the state sectors to implement and, put in more and more money. But finally what happened was they found that it is not possible. And therefore it was necessary to involve the private sector investment into energy, electricity sector. So there was a World Bank report which was based somewhat largely on the experience in the United States of America. So in the USA, the power generation was largely in private sector and was somewhat regulated to a limited extent. The advantage of having that there was that private equity and investment into the power sector flowed at a rapid pace, because they perceived that this is an essential requirement. And so to answer your question, I will deal with that a little later when I come to 2003 Act. The issue was that it is largely modeled on the World Bank report, and which in turn is drawing from the regulatory mechanisms in the United States. So I think for better education, just to understand what has been done in the 2003 Act, it may be useful to look at the regulatory mechanism in the United States.
Thank you very much, sir.
Yeah.
Any other questions, please, from the audience?
Yes, Shreyas, thank you very much. So that was excellent. I just had a question from the perspective of from the historical perspective that you took us through. I'm aware that in other countries, such as in the US and maybe some others as well, the standards actually went through a period where they were competing with each other. In the sense, you had the DC versus the AC war. You had differing standards of voltages being supplied. I just wanted to know, sir, if India actually went through anything similar at all before it settled through what are now the acceptable standards being applied uniformly across the nation, or was it that by the time it came to India, a lot of these issues had actually been sorted out well by the British?
Yeah, thanks to the British India, we had no such issues or problems at all. Now, right from the beginning, it was a 220 volt situation, and 50 cycles per hour was the transmission frequency that was maintained. In small grids also, wherever it was done, because the equipment, largely most of this equipment came from United Kingdom. The first generating plant, as I said, was set up in Shimsha and Shivasamudram. Entire generation system came from the United Kingdom. And therefore, we followed whatever UK was following. And in UK, they had this issue, I think, from a very long time, they had continued the utilization of this 220 volt system for whatever historical reasons, though there is some thinking now that if the voltage is reduced to 110, there would be better utilization of resources, is what they think. But I'm not very sure whether, changeover is possible in this situation now. But to get back to your question, I think we did not face much of a standardization problem, except that in come to railways, British said, that narrow gauge and meter gauge and broad gauge, three different things they put up. Fortunately, they didn't do anything like that so far as electricity sector is concerned. So right from beginning, we didn't have much of a problem so far as standardization is concerned.
Thank you very much.
Yeah.
I have a question.
Yeah.
Firstly, thank you so much. I really learned a lot, and I'm sure everybody can say that as well. We're really looking forward to the session tomorrow as well. I had a question on the way electricity has been generated. So it started off with coal and then moved to hydel, and now they're looking at solar, wind, and nuclear. So has the law been able to keep up with this? And also technology, have they been able to keep up with the kind of technology used and understood how each of these new ways of generating electricity will impact both transmission as well as reaching the ultimate consumer?
Yeah. This question has two components. One is as to what does the law envisage? Does the law look at these things? Does the law recognize these things? Now, if you look at the basic structure of the law that we have in 2003, it allows the sector to be regulated by a special regulator. There's more than one regulator. I'll explain the nuances. Now, the regulator is supposed to look into all these aspects. The law itself does not say what is preferred, what is not preferred, how it should be done, but they've left it largely to the regulators. And I must say that both the Central Electricity Regulatory Commission and the State Electricity Regulatory Commissions, which are set up under the 2003 Act, they've been able to grapple with the nuances and the technological advancements, because they have the benefit of having at least one technical member as part of the adjudication and the regulatory framework. Usually there is a technical member who is member of the commission itself and who also sits in regulatory matters and adjudicatory matters. So technologically, they're able to appreciate the changes and how they react to it. For example, what kind of regulations did they have when it came to open access? What kind of regulations they had when it came to pricing of wind energy because of the extremely, volatile pricing situation that was there. Just to give you an example, the wind energy, solar energy was being supplied at some 15 rupees a unit. It has now come down to less than 2 rupees because of technological advances. So technology and changes that have come about have been actually factored into the regulatory framework. And the regulators, I must say, are doing quite a job. So though the law doesn't particularly make any provision, except that, for example, this open access, what I was talking about, the law provides for it. The law says that, anybody has a right to ask a transmission utility to use their transmission lines for transmitting their energy. That right is given. Earlier it was not given. So like this, some technological advances have been taken note of the law, but the actual implementation is largely the role of the regulator.
Thank you.
Yeah.
Any further questions? Anyone? Please go ahead.
They're all hungry, I think.
Yes, I think so.
They must be hungry for information, intellectual hunger. No, the sector is a bit, what shall I say, unusual, so I don't blame anybody for not asking questions. The reason being that if somebody is just getting introduced to the sector, then it has to get assimilated, and then maybe at the end of the next session, they will probably be able to, come to grips with some of the new provisions that are there.
May I ask, sir, if you will also be covering some of the controversies that we face, such as the Dabhol power plant, the Enron issue, and so on?
Yeah, incidentally, I will refer to the type of problems that have arisen, not only Dabhol and Enron, but also in recent times, number of controversies have arisen regarding the role of the Electricity Regulatory Commission, the role of the generating companies, and the interplay between electricity law and IBC. These are also some things which have come before court. So I'll, try to refer to a few of those cases.
Look forward to that, sir. Thank you.
Yeah.
Shrikant, Shreyas, I've also requested for Mr. Naganand to discuss important contracts and contractual issues that he has seen in his experience and that we can all learn from.
Yeah. Okay, let me see what I can compress into one.
There is one question from a junior person who's, I think, not spoken up, but he's put it in the chat. Ronak, do you want to voice your question?
I saw the question.
Okay.
What are
Ronak,
the trends historically we have seen in public interest litigation relating to electricity laws? Now, you see, public interest litigation itself is a somewhat recent origin, but in electricity sector, what we generally find is there's not too much of interference by courts. The reason being, the sector is extremely well regulated. See, whenever there is a lack of regulation, for example, in SEBI is regulating the securities market. The electricity regulatory commissions are regulating this. The only areas where we find some interference in PIL, in electricity law, relates to environment issues. There have been a number of cases. See, I'll give one example. A power line had to be drawn to connect the western coast of India, that is Udupi and Mangalore, to the mainland for transmission of power to be generated by a company which was set up there. Now, there was a huge hue and cry about it. The matter went to High Court, then it went to National Green Tribunal. And the question was, in order to lay the lines, it's not that some large extent of forest is going to be deforested or anything like that. Here and there, where the pylons have to be placed, there has to be a foundation. And once that foundation is laid and the pylon is erected and the line is energized, the line is going at some 200 feet above the ground level. So there is really no issue at all, so far as that is concerned. But nevertheless, it went to NGT. It was, took some time for the matter to, be heard. And after they appointed a committee to look into it, then that order went to the Supreme Court. And Supreme Court appointed that National Empowered Committee, which went into this. They gave a report to say that the extent of deforestation that is being done is not such a magnitude that it's going to affect the Western Ghats. And thereafter, that was allowed to go forward. This is one area where we find some litigation relating to public interest insofar as electricity law is concerned. That is mainly infrastructure creation aspect. So far as see, public interest litigation need not be coming to court only. The new law vests certain powers in the electricity regulatory commissions to look at it from a public perspective. So there are many issues which public spirited people and those who are affected, they raise it before the Electricity Regulatory Commission in various forms. They could raise it in the form of an issue which comes up in the tariff hearings. When I come to that, I'll explain how tariff hearing takes place. It can be at the stage when when a power purchase agreement, somebody seeks to set up a power purchase agreement. At that examination stage, it is possible for someone to intervene before the Electricity Regulatory Commission and point out that this should not be done. Same thing with the location of generation companies. Even in that stage, it is possible for interference at that stage. Then one more very important aspect in which public can participate freely, not necessarily in the form of a PIL in the High Court, but before the Commission, is in case of tariff hearings. What should be the electricity tariff that you and me should pay? How should that be structured? And whether it should be increased, whether it should be decreased. How are the electricity companies functioning? Are they working efficiently? Are they working below par? Are they allowing people to draw power and not catch them? All these issues come up for debate in tariff hearings, which are public hearings before the Electricity Regulatory Commission. So the PIL concept, if you had only in the traditional judiciary, then my answer is that it is not too many. But if you look at it from a perspective of involvement of public into the decision-making process, there has been a very vigorous and what shall I say, welcome change. I remember one case where the government decided to purchase power from one power generating company, which had its own captive power unit. But they had excess capacity. So if they could, let's say, generate 1 lakh units, they wanted to use 50,000 and sell the remaining 50,000. Then what happened was, this remaining 50,000, at what price it should be bought was the question. So the government and that company went into an agreement and they agreed on a price and they started procurement. The Electricity Regulatory Commission stepped in and it said, Dukia, I want to know how you set this price. Was it a public tendering? Was it based on cost plus something? But how did you do it? And they wanted to look at the records. And government had no answer as to how they arrived at that figure. And finally, the Electricity Regulatory Commission came in and stepped in and said, no, you cannot pay this. This is too high. You're going to reduce it. So this is how proactively, with and without the assistance of participants from the public, the regulatory commissions are functioning. Of course, that decision which I talked about finally went to Supreme Court and it is now in cold storage in Supreme Court. Now, anything that goes to Supreme Court is always in cold storage. We don't know how long the cold storage will last. Except if Arnab Goswami goes, he will get instantaneous justice. Okay, one more question. Price should be regulated. Yes, it is regulated. There is no doubt about it. The price at which a generating company will sell to a transmission company is fixed by the State Regulatory Commission. The price at which the distribution company sells to the consumer is also fixed by a tariff fixation done by the Regulatory Commission. This exercise is done after an elaborate exercise. The electricity distribution companies have to file what is known as next year's projection of tariff. And in that projection, they have to give their cost of purchase. They have to give their technical and distribution losses. They have to give all their figures. And based on that, the commission, after a public hearing, will look into the cost of supplying and then approve the tariff. Same thing when it comes to selling power from a generating company. This exercise is done. And progressively, what has happened is that procurement of power is now going in terms of an open procurement policy. It is no longer negotiation. It is an open bid policy. So if I want to set up, let's say the state wants 1,000 megawatts of solar power to be set up in the state. It can invite a bid and say, see, we want a license 1000 megawatt power capacity in the state. These are the areas. Anybody interested in setting up a plant may make a bid and give you a rate at which you will supply. So these open bids are received and competitive bids are examined. And under the Transparency Act, they have to follow a procedure that is followed. And competitive price at which a license or a permission is given to somebody to set up a generating plant. So there are both methodologies. So I think your relatives in Gujarat, they must be watching Sony, Indian Idol, and lot of Netflix movies, and keeping their air conditioners on every day in all the rooms, including the kitchen. So they may be paying that much. We are very conservative. I hope that answered your question. One more
Thank
question.
you. Yes, there's one more question.
Is there a complaint regarding the billing of electricity consumed? And can the consumer approach dispute resolution forum or state? There is a forum available. Any dispute, there is a body which is set up under the electricity by the Electricity Regulatory Commission under the E&SC code, it is called. There is a redressal forum that is there. And once that redressal forum takes a decision, against that you can go up to there is an ombudsman that is appointed. The ombudsman can look into that. I recently did a case where before going through this procedure, so a very old standing dispute, a company had gone to the writ court, writ petition, and after an elaborate hearing, the court accepted our argument that so far as the quantum of the demand is concerned, if that is challenged, it is not appropriate for the High Court to decide it. It's most appropriate for this forum to decide it. And from the forum, it has to go to the ombudsman if somebody is unsatisfied. Okay.
Thank you. Thank you once
Everybody's
again.
run out of steam, I guess.
Yes. Look forward to hearing from you tomorrow.
Okay.
So for
Tomorrow
everybody,
there's a small problem. Let it remain as it is. I have
Okay.
2 matters before Supreme Court. My guess is that within the last working day, those will be over before 12 o'clock. So around 11:30, I will review and message some of you to say if that needs to be moved a little bit. Otherwise, we leave it at 12.
no problem. We're okay to move it.
Okay.
Yeah. Thank you very much.
Thank you. I hope everybody found the presentation is okay and useful.
Definitely, sir. You'll see all those icons coming up right now. We're all very grateful to you, sir. Thank you.
Thank you very much. See you all tomorrow. Bye.
Thank you.
Bye.
Thank you, sir.
Bye.